So we have this question, rules of interpretation. Okay, so what is interpretation? Understanding meaning of a certain statute or a given provision. And then there are different rules which are applied in order to understand the provisions. Okay, there are 4 different rules that we get to see. Now, first of all, we have literal or grammatical rules. So do you remember what is literal rule? Literal, when we say, it's like exact meaning, like the literal meaning we try to apply. Okay, so literal or grammatical rule. According to this rule, the words used in the text are to be given or interpreted in their natural or ordinary meaning. Generally, what a certain word means, that ordinary meaning or that literal meaning we try to apply, and we try to understand a certain legal provision. According to this rule, the only duty of the court is to give effect to language of the statute. That in the statute it is written, we just need to understand the meaning, and we need to understand the provision. Okay, by giving meaning to the words, or by giving meaning to the provisions, we try to derive a meaning. There is no business of the court to look into the consequences which might arise. What will happen if we understand it in this certain way and all? Court should not be concerned with that, but court should rather focus on the literal or grammatical meaning. What does certain word actually means, that should be applied, and case needs to be decided accordingly. Okay, so there was this case, State of Kerala versus Mathai Murgis. So in this case, a person was caught along with counterfeit currency dollars. Okay, fake currency dollars he was caught with. And he was charged under sections 120B, 498A, 498C, 420 of IPC, read along with 511 and 34. So 34 is nothing but common intention, 511 punishment for attempt to commit a crime. Okay, 420 cheating, 498A. Okay, 420B, all these provisions the person was charged with. Now, punishment for criminal conspiracy. So what happened here? The provision is that whether, okay, that this person was charged under currency notes, right? Fake currency dollars. So it was charged that whether, when we talk about currency, okay, counterfeit currency will include only Indian rupee, or it can also include dollars or not. That was basically the question. Okay, so because IPC is applicable in India, right? So when we talk about currency in terms of Indian Penal Code, is it going to cover only Indian currency, or even for dollars, counterfeit currency dollars? For that also person can be punished or not? Okay, so the person said that I'm just having counterfeit currency dollars, so for that IPC should not be applicable to me. Okay, the accused contended before court that the charges under 489A, B and C, 489A and C of the Indian Penal Code can only be applied in case a person is having counterfeit Indian currency notes, but it cannot be applied in case of foreign currency notes, because we are talking about Indian Penal Code, IPC. But the court held that the word currency notes or bank note cannot be prefixed. The person was held liable, and charge sheet was also filed under these provisions. That it talks about counterfeit currency notes. So whether it is Indian or some foreign currency notes, all the provisions it should be applicable. So currency notes, what would be the literal meaning? The currency notes of any country. When we say currency notes, It's not restricted to Indian currency as such. So that is how court tried to interpret the provision, that when we say currency notes, it should include any currency. So that's how you would be held liable and charge sheet. The person was charge sheet as well. Okay, so literal or grammatical rule, exact meaning of a certain word, we just try to apply and we just try to understand meaning of the provision. Okay, is it clear? Literal meaning, is it clear, the case? Hello, is the case clear?
Mom, can you repeat it again, mom? I understood, but perfectly I didn't understand.
So the charges were that if you are having fake currency notes, right, there is a provision under IPC under which a person would be fined. So in the provision, it just says currency note. It do not mention Indian currency note or something. Right. So the question was, when we use the word currency note, does it include only Indian rupee or will it include foreign currencies also like dollar? Court said when we hear the word currency note, what currency note mean? Currency note of it might be any country, not just India. So like that, it was understood and the person was held liable over here. That even dollars would be included when we say currency note. It cannot be restricted to Indian rupee only. Okay, so what is currency note? Any currency we can say currency note, right? Not just Indian rupee. That's how it was understood in this case.
Yes, ma'am.
Okay, that's nothing but literal rule. What a certain word means in general. In general, currency means currency of any country. That's how it was applied. Okay, next we have is mischief rule. So what is mischief rule? Mischief rule is that some problem is there. Okay, in the statute, there might be some problems. So we try to understand the provision in such a way that that problem can be addressed. Okay, that shortcoming or that problem can be addressed by us. That's nothing but mischief rule of interpretation. So what happened in this case where mischief rule was applied? Okay, Smith versus Hughes. In this case, around 1960s, prostitutes were soliciting in the streets of London. Okay, first of all, what happened? They were soliciting in the streets of London, and it was creating huge problem for the public. Okay, in order to address this problem, legislation was also introduced because previously they were not having any legislation as such. So to address this issue, a legislation in fact was uh, introduced, that is Street Offences Act 1959. Now, once this legislation was introduced, it talks about street offenses, right? As in an offense committed on the street. So after enactment of this act, what happened is prostitutes started soliciting from windows and balconies. Now, windows and balconies means inside a house, right? But you are talking about street offenses. They are not committing any offense on the street, right? But they are doing something from windows and balconies of their house or the room. So in this case, mischief rule was applied to remove the gap in the legislation. So why this legislation was introduced first of all? Right? It was introduced in order to address this problem of soliciting in the streets. So if they are trying to find a gap and still this legislation is like meaningless, we need to interpret it in such a way that we can fill this gap. Whatever problem is there, that we can address. Okay, so what court did is court applied mischief rule. Okay, and court held that windows and balconies were taken to be an extension of the word street, and the court made prostitutes liable for soliciting from the windows and balconies under the Street Offences Act. That when we talk about Street Offences Act, it's not restricted to street as such, but it would also include windows and balconies, which are nothing but an extended part of the word street. Okay, so in order to address the problem or in order to address the gap, mischief rule was applied. So that's what mischief rule is, that a legislation is introduced for a certain purpose. If that is not being satisfied, we try to interpret it in such a way that this gap can be addressed, this limitation or shortcoming can be addressed by the court. Okay, is it clear?
Yes, ma'am. Instead of extension, they would make it as a illegal, ma'am. Prostitution as a illegal instead of extension.
Sorry?
Ma'am, instead of this extension,
Yeah.
like they would have make like illegal prostitute, like making prostitution as a illegal.
No, the legislation, what is the purpose of this legislation? Purpose of this legislation was it is creating problem for the public because it was done on the streets, right? So that they tried to address it. What is the purpose of this legislation? Not to make it illegal as such, right? Not to make prostitution illegal, but to reduce whatever problem people were suffering because it was done on the streets, right? So they want to address this problem. For what the legislation is introduced, that should be addressed. If that is not addressed, that gap can be removed.
Is state offense is applied in even in India, ma'am?
No, not in India. This like the rule is applied in other countries also. So in the same way it was applied. It's not Indian legislation. Okay, so whatever is passed from parliament or state legislatures, only that would apply in India, not from foreign countries it would apply. Okay, that's why we say it's sovereign. Okay, there was another case which was Indian. Okay, we'll see this. This is also where mischief rule was applied to address the shortcoming. Okay, so we try to see for what reason or what purpose this legislation was introduced. Is that purpose satisfied or not? Okay, if that purpose is not being satisfied, we try to understand the legislation or a certain provision in such a way that it can be addressed. Okay, so this was Pyarelal versus Ramchandra. What happened here is a person was prosecuted for selling sweetened supari, which was sweetened with the help of artificial sweeteners. Okay, when we talk about sweetened supari, artificial flavors, artificial ingredients are used. So he used to sweeten it with artificial sweetener. He was prosecuted under Food Adulteration Act. Okay, that you have adulterated the food and you are responsible. Now, what Pyarelal said is that supari is not a food item. Okay, in general, when we talk about food, we mean something which is, like breakfast, lunch, what we can have, solid sort of a thing. But supari as such is just like a mouth freshener or something. It's not food as such when we understand the word in general. So the person said that supari is not a food item. But the court held that dictionary meaning is not always the correct meaning. We cannot always apply the literal meaning or the grammatical meaning or the dictionary meaning everywhere. Therefore, mischief rule was applied in this case. An interpretation which provides remedy shall be taken into consideration. So court held that the word food will include anything which is consumable by mouth or orally. Thus, his prosecution was held valid. When we talk about food, it's not what you eat for breakfast, lunch, or dinner, but it would also include any mouth freshener or anything which can be consumed by the mouth. Okay, that would also be included because supari can be consumed with mouth. This also will be coming under Food Adulteration Act. So what court will see? What is the purpose of this legislation? They want to prevent adulteration of food, right? Whatever people are eating, their adulteration should not happen. If we are eating supari also, there also this act should apply. The person cannot escape saying that supari is not food or something, right? That shortcoming needs to be addressed, and legislation or the provision has to be understood in such a way that it makes sense. Okay, this legislation, whatever purpose it was introduced, that can be satisfied. Okay, is it clear?
Yes, ma'am.
Okay, so literal meaning or grammatical, same exact thing we will apply it. When we talk about mischief, it should be understood in such a way that the problem or the gap can be addressed. Then we have this golden rule. Okay, so it is known as golden rule because it solves all the problems that arises in interpretation. The literal rule follows the concept that we should be applying the natural meaning. Whatever is the natural meaning, that should be applied. But when we give the natural meaning, sometimes it might create problem. Okay, sometimes it might not provide justice to the parties. It might rather create problem or hardship. In such cases, what court will do, if applying natural meaning or the literal meaning is creating problem or giving hardship or not providing justice, court will modify. Okay, court will modify the meaning to the extent of injustice caused to prevent the consequences. As in, court will modify or change the meaning to such an extent that this injustice or this problem can be removed. Okay, so like that, court will try to understand the provision that sometimes literal meaning would not work. So we need to twist it in such a way that this injustice can be removed. All right, we have this case, State of Punjab, Punjab versus Qasir Jahan Begum. What happened here is, this is relating to period of limitation. Okay, so period of limitation was prescribed for under Section 18 of Land Acquisition Act 1844, that appeal shall be filed for the announcement of award within 6 months of announcement of the compensation. Okay, so what happened? There is a legislation, Land Acquisition Act 1844. Under this legislation, if someone's land was acquired, and compensation will be provided, right? Whenever land is acquired, compensation will be provided. So the moment compensation is announced that this much compensation you will be getting for the acquisition, if you are not happy with the compensation and if you want to file an appeal, you should file it within 6 months from date of announcement of compensation. Okay, when the compensation was announced, from that within 6 months you should file the appeal if you are not happy with it. What happened in this case is, award was passed in name of this person. It was intimated to her after period of 6 months about by her counsel. Okay, so she was not aware about what compensation has been awarded. Her counsel or her advocate informed her about it only after 6 months from date when it was announced. Okay, so she was not present when this compensation was announced, and her advocate informed her after 6 months only. So she wanted to file an appeal after 6 months, but then law said that within 6 months you should be filing the appeal. So the question was, can we make changes over here? Because it's not her fault, right? She was not aware that compensation is being announced. She came to know after 6 months only. So in this case, the appeal was filed beyond the period of 6 months. The appeal was rejected by the lower court. Lower court said that 6 months time is already over. And what the legislation says, 6 months of announcement of compensation. So this only we will understand. Exact literal meaning, if we see 6 months is already over, your appeal is rejected. Okay. But it was held by the court that the period of 6 months shall be counted from the time when uh, but she approached the higher court, and higher court said that no, that is not how it would be done. But 6 months period will be counted from the time when she came to know about the announcement, not from when announcement was made, because this is not making sense. This is creating injustice for her, right? So from when she came to know, from that time we will count 6 months period. And by applying golden rule, her appeal was also allowed. Because why this provision is there? That if you should not be like, okay, I came to know about the compensation, but I'm too lazy to go to the court, that I will go to the court after 6 years. Right? In order to address that problem, only limitation period is fixed, that we should approach the court as soon as possible. But that does not mean that she would not be allowed because she was not even having knowledge, right? Limitation Act, you would often see, even though we have the provision, right, there is something called as condonation of delay. People approach the court saying that because of this reason there was a delay, and if court is satisfied with the reason, court often allows uh, extension of period as well. Okay, same thing happened here, that if we try to apply the literal meaning, it will create injustice for her. So court tried to twist it in such a way that it can do justice for the parties. Okay, is it clear?
Yes, ma'am. Ma'am, did she get the compensation what she expected?
No, this is just relating to limitation, the period of limitation where this rule was applied. Whether she got the compensation or not, that is like a different matter, because we are talking about the appeal, whether it should be preferred or not. Okay, so that whether she got the compensation or not, that would be like a case under Land Acquisition Act. Where the literal golden rule was applied, that was relating to limitation, whether appeal should be allowed or not. Based on that, this golden rule was applied. Okay, so appeal should be allowed even beyond 6 months period, because that is what would give justice to the parties. Okay, there was another case, State of Madhya Pradesh versus Ajad Bharat Financial Company. What happened here is that there was a transporting company. Okay, a transporting company was carrying a parcel of apples, was charged sheet. Now what they were carrying? Parcel of apples. Someone else gave them the parcel and they said that this parcel contains apples and carry it from this place to that place. Okay, and while doing that, this transport company was charged. What happened is that the truck of transporting company was impounded as the parcel contained opium along with apples. So when they were checked, they found that it's not just containing apples, but it is also containing opium inside the parcel, inside the truck. Okay, so it was impounded. It was like seized by the authority. At the same time, the invoice shown for transport consisted of apples only, because they are just a transporting company, right? They are just transporting things from one place to another. And when they were given the order, they were given an invoice also wherein it was mentioned that only apples are contained here. Right? Transporting companies would not check each and every parcel what is given, right? Their job is simply to transport it from one place to another. So they did not check it based on the invoice. They were transporting the apples from the place. But later on, they came to know that it contained opium as well. So Section 11 of Opium Act, all the vehicles which transport it may be shall be impounded. Okay, what the provision says, it shall be impounded. That there is no provision as such that like discretion of authorities or anything. If something is carrying opium, it shall be impounded, it shall be seized, and the articles will be confiscated. It was confessed by the transport company that they were unaware about the fact that opium was loaded along with apples in the truck. So the court held that although the word contained in section 11 of the said act provided that vehicles shall be confiscated, but by applying literal rule of interpretation for this provision, it would lead to injustice and inequality. Okay, therefore we need to make changes. So when we say shall be confiscated, that means it's not optional, it's mandatory. It shall be confiscated. But when we say may be confiscated, that means it's having the option. It may be, may not be, depending on what the authorities decide. Right? So when we apply the literal meaning, that what shall be means not optional. If we apply that rule, it's not giving justice, because transporting company would ideally not check what's there inside the parcel, and same they also did. They were not aware what is there along with apples, so they were transporting. So if you are seizing or if you are impounding the vehicle, that is creating injustice because they were not aware of it, right? So rather than understanding it as shall be, we will understand it as maybe, so that we can remove this injustice that otherwise this legislation would lead to. Okay, is it clear?
Yes, ma'am.
So all the cases, literal meaning might not be making sense. Okay, sometimes it might lead to problem, it might create injustice. So we need to twist it to such an extent that injustice can be removed. So rather than understanding it as shall, we will understand it as may. Rather than completely following this limitation period, we will try to count it not from the day of announcement of compensation, but we will try to count it from the day when she came to know about it. That's how we try to remove the injustice which otherwise a legislation would lead to. Okay, then we have harmonious construction rule. So what is harmonious construction rule? It says harmony, right? What is harmony? Two things existing at the same time peacefully, without conflict, without confusion. Right, so harmonious construction rule means that two or more provisions of the same statute, it might be conflicting with one another, right? One statute will have so many provisions, so many sections. Sometimes we might feel that one section is saying something, another section is saying completely opposite to it. It's conflicting with one another. So because these are provision of the same statute, how do we allow it to harmoniously exist? How do we allow both the provisions to remain in the statute without conflicting with each other? Okay, there this provision is applied, harmonious construction. That is this case MSM Sharma versus Krishna Sinha. Okay, this is relating to parliamentary privilege. What happened here is, we have Article 19, Clause 1, Clause A of the Constitution of India, which provides for freedom, fundamental freedom. Okay, and it provides for freedom of speech and expression, that we are free to express ourselves, we are free to express our opinions and viewpoints. That power is given. Okay, and under this, we have also freedom of press is also given, like newspapers or other publishers, TV and all, they can also express their viewpoint. Okay, freedom of press is also part of it. So Article 19(1)(a) provides us fundamental freedom of speech and expression. Also, there is another provision under Constitution, Article 194, Clause 3, which provides to the Parliament for punishing for its contempt, and it is known as parliamentary privilege. That sometimes Parliament can say that this certain part, whatever is discussed in the session, it shall not be published. Okay, and if this part is published, it would be considered as violation of parliamentary privilege. Okay, Parliament is given the privilege that they can say that this certain part should not be published. There is this also, right, Rajya Sabha and Lok Sabha, some YouTube channel is also there. Have you checked that on like official YouTube channel is there for Parliament? Have you come across that anytime?
No, ma'am.
No. Okay, there is one. Okay, so during the sessions, right, it would be published there, like whatever happened in the session, right, it would be published. So sometimes you would see that some parts may be removed, not the entire session would be given because of parliamentary privilege. Okay, certain parts would be removed from this entire video because of parliamentary privilege, and same ways they would say that this certain part should not be published. Okay, so in this case, what happened is, editor of a newspaper published the word for word record of the proceeding. So there was proceeding of Parliament wherein they said that this certain part should not be published, but this publisher, what he did is word for word everything he published, including those portions which were, like they requested that this part should not be published under parliamentary privilege, but that was also published. He was called for breach of parliamentary privileges. It was said that Parliament is having parliamentary privileges when they clearly said this certain part should not be published. Why did you publish it word by word? Right? It is violation of parliamentary privileges. The person was charged under this provision. Now, this publisher said that he is having a fundamental right to speech and expression, right? That there is Article 19 clause 1 clause A that provides me fundamental right of freedom of speech and expression, and I am free under this provision to publish my to publish it, right, to make it public. It was held by the court that Article 19(1)(a) itself talks about reasonable freedom, and therefore freedom of speech and expression shall pertain only to those portions which the parliament had not said that this part cannot be published. Only to that extent it would be applicable. Okay, so there was conflict between these two provisions. One is giving you freedom of speech and expression, another is giving parliament the privilege. So which one should prevail? There was a conflict between the two. So court had to apply harmonious construction. Court had to interpret it in such a way that both the provisions can remain under constitution. So what they said is, when we talk about Article 19(1)(a), it is giving you freedom of speech and expression, but that's not absolute freedom. It is subject to reasonable restrictions also, right? And freedom of parliamentary privilege is also one such reasonable restriction. So if parliament has said something, that should be obeyed. Okay, so that's nothing but harmonious construction. Two provisions still remain. You have a freedom of speech and expression, but it's subject to some limitation. And this is what one limitation was. Is it clear?
Yes, ma'am.
Okay, so depending on the situation, we need to see what rule can be applied. It's not that one rule would be applicable for every single case, because cases are so, like there is such a difference in terms of the cases. So we need to see what rule can be applied in what given situation. Okay, so these were the rules. You need to read the cases for this also.